Peace and love, family. Let me tell you something about your government, right? Your government never leads off with what your appeal rights are. That is usually at the end. If not said, it's in writing at the very end of the document, usually in small print. They will begin more so in kind of an aggressive manner to get you to concede to whatever the allegations are, whatever the charges are up front, right? And drill you in. So no matter how you are describing or trying to explain what happened, trying to give some type of defense, when the charge or when the action is being brought to you, that does not qualify, right? You have to be in a proper state. Like, in other words, make it simple. You have to approach at the proper time in the proper capacity, official capacity, when it's time for your appeal, for your defense to be heard. So initially, your defense is not being heard. So sometimes what I'm seeing, usually dealing with procedural matters within an agency, within a department, within some type of government agency, before it has reached the point of going to court, right? Is that a lot of times our people are trying to make a defense at the very beginning when the allegations or charges are being brought, rather than reading down at the end of the narrative where it tells you how to appeal, going through that process and there making your defense made. That's where you begin to put them in a position where they have to respond to your defense. If you are defending in the process by interrupting or interjection or making interjections, say even on a document where it's not a document that is for appeals, or you're in conversation and you're injecting defense where the conversation is not about a status to hear your appeal rights, you're not being heard. You're not being heard. Now, you may get swifty with it, like as the issue escalate to a point where there's a judicial hearing or court hearing, and you may have a lawyer or somebody who has jurisprudence to establish that, hey, this person did initially make these same claims at the initial beginning, and therefore we missed the appeal because of there was no procedural justice in play to allow my defendant to understand when they were to make their defense. You may be able to mitigate the circumstance, but just a common practice is when charges or allegations are being brought, one of the key things is, after they've done whatever they're saying, is to ask, what is the appeal process? What are my rights? How can I contest this allege? And whatever the procedures are, if you even have questions about how that procedure is to be, document it. Document your questions. If you have to, record your questions. Document it that you're asking these questions and what date, what time, and so forth. So that's just a little tip, because too often what happens is our people, they try to defend themselves in at an improper time, should I say. And then when it escalates to a court situation, in some ways people will submit and just want to just get it over and, whatever, make payment arrangements or make some type of arrangements when they feel the whole time, they were unjustly heard. They were unfairly treated. They were out of duress. They got muscled into submitting to the will of an unjust act. So hopefully that helped with something maybe you're dealing with, or something in the future that you will have to deal with in the future. Peace and love. This is S. Marshuel. Talk Bills. Peace and love. I'll see y'all in the wind.